Hey, Paul here, and in this video we're going to discuss whether a conduit trust should be a beneficiary of your traditional IRA. Okay, so naming a trust as a beneficiary of an IRA has always been somewhat complicated. Now the rules have changed and it's still complicated. So in this video I want to go over some things and let me just give you the big picture. Many of you married folks out there who own IRAs, you've named your spouse as your 100% primary beneficiary. And then you named perhaps contingent beneficiaries. Could be children, could be a trust, could be charities, could be estate. So those of you who kind of made an informed decision to name your spouse as your 100% primary beneficiary, that's not likely to change because the rules regarding naming a spouse as the beneficiary of your IRA haven't changed. But the rules required for naming a non-spouse as a beneficiary, and maybe if you named your spouse, you named children or others as the contingent beneficiary, or if you're not married, you named people, obviously not a spouse, as the primary beneficiary. This really applies to you. So it's an important video. I'm going to take it one step at a time. Let's dig in. All right, so I got to give you a little history first. Under the pre-2020 rules, a non-spouse individual, actual person who was a designated beneficiary was entitled to take required minimum distributions over their life expectancy. Let me give you an example. Before an IRA owner died before January 1st, 2020, named, and let's say he had a $1 million traditional IRA and he named his son as the designated beneficiary. And at the time that the dad or the IRA owner died, the son had under the IRS tables, a 40-year life expectancy. So that IRA account would be moved into an inherited IRA account in the son's name, and the son could, if he wanted to, just start taking these required minimum distributions based on his life expectancy. So if in the year after dad died, son's life expectancy was 40 years, the son was only required to take 1/40th of that IRA out of that inherited IRA and pay tax on it. So if it was $1 million IRA, 1/40th is 2.5%. The son would take out $25,000 out of that $1 million IRA. He'd pay tax on that $25,000. Let the remaining $975,000 grow tax deferred. And then in the next year, the son roughly would have a 39-year life expectancy, would take out a slightly larger than 2.5% distribution. And really the effect of it was the son could get a really nice, gradually growing income depending upon the investment performance of the IRA, but the son would get a kind of gradually growing distribution from that IRA for the rest of his lifetime. It really worked out well. Now, however, since that son who was the beneficiary could, if he wanted to, take more than the required minimum distribution, he could say, I'm gonna take the whole $1 million first year. Yeah, I gotta pay tax on it. And then, he takes out the $1 million, he pays $400,000 of tax, and then he blows the $600,000. Since beneficiaries could, if they wanted to, take out more than the required minimum distribution, some IRA owners didn't want to give their beneficiaries that option to take it out sooner than their life expectancy. So Congress provided a mechanism allowing those needing to name a trust as a beneficiary of the IRA to get the favorable stretch post-death tax treatment afforded to designated beneficiaries who are individuals. So what Congress came up with in the regulations was if a trust that is named as a beneficiary of an IRA meets 4 requirements, and then it's entitled to what's called this see-through tax treatment, which allows the life expectancies of the underlying trust beneficiaries to be used for required minimum distribution purposes. So those 4 requirements that must be in a trust, they're fairly easy to meet. The first one is that the trust must be valid under state law. Well, that's not too difficult to meet. The second is the trust must be irrevocable upon the IRA account owner's death. Also, that's typical. Trust must provide that all applicable trust beneficiaries must be identifiable in the trust instrument. Also not difficult to meet. And then the fourth is a copy of the trust instrument must be provided to the IRA custodian at a certain date the year after the IRA owner dies. Also not real difficult to meet. So as long as a trust meets those four requirements, then you can look through the trust and use the individual's life expectancies for determining required minimum distributions. All right, so there were, still are many trusts out there that are beneficiaries of IRAs. They meet these see-through requirements, and it's likely the language in that trust says that the trustee shall withdraw the required minimum distribution from the inherited IRA and distribute it to the beneficiary. So people who did that were the dad who says, I know my son is permitted to stretch out distributions, but I want to require it. I don't want to give him the opportunity to just blow it all at once. I'm going to leave my IRA to a trust for the benefit of my son, name some other responsible party or as trustee. And I'm going to provide that the trustee is required to take those required distributions from the inherited IRA and then just distribute them to my son every year. And that way the son is guaranteed to get that income for life. So that was a fairly common scenario, and it was all set out to work very well. And then this new Secure Act was passed, and it was passed effective for IRA owners who died on or after January 1st of 2020. What the Secure Act did was it eliminated these stretch provisions, and the Secure Act required that all funds from an inherited retirement account must be distributed from that inherited retirement account by the end of the 10th year after the IRA owner's death. Now, there is a very limited group of people that still can stretch required minimum distributions over their life expectancy. And I'm just going to say this just so you'll know it, but most beneficiaries don't fall under this limited group of the disabled, the chronically ill, individuals who are within 10 years of the deceased IRA owner's age, and minors, but minors can only stretch it while they are minors. Once they turn 18, they're what's called a non-eligible beneficiary, and they got to take all the money out by 28, or at 28. So let me give you an example with all that being said. An IRA owner names what we call this see-through or conduit trust. The conduit trust means that the distribution is made from the inherited IRA to this conduit trust, and then the trustee immediately distributes the distribution from the trust to the beneficiary. And so what that does is it keeps those distributions from being accumulated in the trust where tax rates are much higher. I'll do another video on accumulation trusts. All right, so an example, IRA owner names one of these see-through conduit trusts as beneficiary and provides that the trustee is to take required minimum, I'm struggling with that, required minimum distributions annually and distribute them to the beneficiary. So under my example, dad had $1 million IRA, named a trust for his son as the beneficiary of his IRA. It was a see-through trust, it was a conduit trust. So that worked out well because son would get, virtually equal and maybe even a little bit increasing distributions over his life expectancy. Worked out great. But under the new rules, the definition of required minimum distribution on inherited IRAs is completely different. So with that old see-through conduit trust, which would have given son an income for his life, Under the new rules, with the required minimum distribution definition being all funds must be dispersed out of the inherited IRA within 10 years after the IRA owner's death, if there's that traditional or customary conduit trust, which requires the trustee just take required minimum distributions, the effect of the new rule is that when dad dies and son has a 40-year life expectancy, son doesn't get anything for 10 years, and then he gets it all 10 years after dad dies. And again, that's not going to make sense from an income tax standpoint, because it's all going to be lumped into son's taxable income in only 1 year. And it's probably not what dad would have wanted, is for no distributions to be made and then one whopper distribution to be made 10 years after dad died. So with these old see-through conduit trusts, they're likely going to need to be replaced. And they'll either be replaced by dad just naming son as the beneficiary of his IRA. Dad's thought process might be, well, I'm going to name my son as the beneficiary. If he blows it, he blows it. The best I can do if I use a trust as a beneficiary is postpone distributions for 10 years after I die. I'm just going to name my son as the beneficiary. Although some will still want to use these, these see-through conduit trusts. And when they do, those trusts will have language in them that will say something like, yes, the trustee shall withdraw the required minimum distribution and distribute it to the beneficiary. That'll take care of any funds that are still in the inherited IRA account 10 years after the IRA owner dies. But that trust will also likely include language that says that the trustee is authorized to take distributions in excess of the required minimum distribution and distribute it to the beneficiary. So when it's set up that way, kind of the best case scenario under these see-through conduit trusts perhaps would be that after dad dies, maybe the trustee just uses that authority to take distributions in excess of the required minimum distribution, and maybe makes somewhere around 10 equal payments over 10 years after the IRA owner dies to that beneficiary. So it may help minimize the income tax liability, because there won't be one big one at the end of the 10 years. And from a control standpoint, it's giving that beneficiary 10 equal payments, where if they blow the first couple of payments, they may learn from that and realize, hey, as I get these payments, maybe I should hold on to some of this money. So you may see some of that in the see-through conduit trust area. Now, what we haven't addressed in this video, and I will address in a video that will likely be next, is when an IRA owner designates what I'll call an accumulation trust as the beneficiary, and that's where the trustee maintains more post-death control of the retirement assets, even perhaps much longer than the 10 years after the IRA owner dies. But that comes at a potentially high income tax cost, because as that trust accumulates those distributions, then the trust is likely to have to pay income tax at trust income tax rates, which are likely to be 37% on those distributions that are accumulated in the trust. So a lot there, but it is a really important issue. My suggestion to you is, if you named a trust as a beneficiary of your IRA, you need to have it reviewed. You may need to have it replaced in light of the new Secure Act regulations that took effect for IRA owners who die on or after January 1st of 2020. Fortunately, if you're watching this video, you haven't died yet, and you have an opportunity to fix all of this, because at any time you can change your beneficiary. even though you may have named an irrevocable trust as the beneficiary, it's not an irrevocable beneficiary designation. You can replace that trust as your beneficiary. So a lot there, but just know that it's an important issue. Got to address it. Take a look at it. Smash the like button. Obliterate the subscribe button. Hit the notification bell so you don't miss anything. We'll see you next time. That was a mouthful. I'm Paul Rabelais. Have a great day.